Hello and welcome to Bold Radio. I'm your host, John McLeese. Sometimes in life, you just need some good advice. No one is an expert at everything. That's why we're proud to present the Bold Radio Expert Series, where we welcome a qualified and experienced individual to offer sound advice on an aspect of running a business. Our guest today is a highly qualified legal expert. We're pleased to be joined by Shereese Qually. She's a lawyer and partner at the Winnipeg law firm Taylor McCaffrey LLP. Shereese will be bringing her expertise today on a few top employment tips. Now, as a business owner, you can't know everything about labor law, but since we have a lawyer here with us today, we'll address a few points that you absolutely should know. Shereese, welcome to the program.
Thank you.
It's great to have you. What is your top tip, right off the top, for hiring an employee?
Well, ironically, my top tip for hiring is to prepare for firing. So it's looking to the end of employment at the beginning of employment. And what I mean by that is that the largest potential area for liability really in terms of employment is regarding termination. And you can prepare for that right when you hire an employee. And you can do that by having an employment contract. Every time you hire an employee, you do have an agreement, whether it's verbal or written. And I strongly recommend that employers put in place written employment agreements. And the key thing to have in your written employment agreement is a termination clause, a valid, enforceable termination clause that would limit the notice that an employer has to pay an employee if they fire them without just cause. That's the most complicated area and the easiest to take care of right up at the front.
So it's very interesting you mentioned that. So regardless of performance or anything, if you decide to terminate somebody, it's good to lay out what those conditions of termination would look like.
So it's good to lay out that if you're going to terminate without cause, how much you're going to pay in terms of notice or how much notice you're going to provide, and limiting that right away in the employment agreement. You can also set out other terms in terms of the expectation for hours, what sort of benefits you're going to provide, their duties and obligations. It's just better to have it all in writing.
Firing an employee can be a really difficult reality in management. You've alluded to some of that already. What tips can you offer on the whole notion of terminating?
So ironically, it's interestingly, it's tied to my last answer, and it's really about understanding what your obligations are as an employer on termination. It goes back to the concept that an employer can terminate an employee at any time as long as you have one of three things. One is just cause, having an employee do something bad enough that it's just cause, you can fire them, you owe them nothing, get rid of them. The truth is that doesn't happen very often. It has to be a fairly significant, serious act or a long, drawn-out series of warnings before you have that. So you either have just cause or you provide working notice or pay in lieu of notice. And so my key tip on termination is understanding what notice is, understanding what obligations you have in terms of notice. Many employers, many employers, call me thinking that all they owe is what's set out in the Employment Standards Code. And if you call the Employment Standards Branch, that's what they'll tell you, is that you just have to pay the Employment Standards Branch code notice. But what's important to know is that employees are entitled to notice from two sources. One is the Employment Standards Code, and the other is the common law. So the code, which we historically think of as your 2 weeks, we'll give you your 2 weeks. It's now between 1 to 8 weeks under the code, depending on how long you've been working. That's the base floor of rights, the very bottom. The other area is from the common law, and that's what we think of as wrongful dismissal. Mm-hmm. You can sue for a wrongful dismissal. The liability there is much larger and can be as much as 24 months of notice, depending on how long the employee's been working there, how old they are, the nature of their position. And so the important thing to know when you're firing an employee is what your potential liability is, because that can really surprise you if you think your maximum liability is 8 weeks and it ends up being a year or 18 months. So circling back to my first tip on hiring, you can limit that liability under the common law with a valid enforceable termination clause that says what notice you'll pay. You can limit it to the Employment Standards Code. You can't go below the code, but you can make it the code. And so you can limit this potential top of 24 months to 8 weeks by planning properly on hiring.
And putting it in the agreement.
Shereese
Qually is a lawyer and partner at Winnipeg law firm Taylor McCaffrey. She joins us today to talk about top employment tips. Let's talk about an area that could use some clarification, Shereese, managing overtime. What advice can you give on overtime wages and obligations?
Sure. So again, my top tip on overtime, understand what your obligation is. Under the Employment Standards Code, most work performed will require overtime pay, being 1.5 times pay or time off, for over 8 hours a day or 40 hours a week. And again, many employers think they have validly gotten around that by entering into an agreement that says, this is salary, everything's included, or there's no overtime here. Those agreements are not enforceable. And so the problem with that is that you operate that way while the employee can be accruing tons and tons of overtime hours and tons of money you owe them. And then when things go south at the end of the employment, they will bring an employment standards complaint. They'll bring a Queen's Bench action for thousands of dollars of overtime that they worked. So it's important to understand that most positions are entitled to overtime, over 8 hours a day or 40 hours a week. There's exceptions, narrow exceptions that an employer should be familiar with. And the most significant one is usually managerial exceptions. This is another warning on the managerial piece, is that just because you're called a manager doesn't mean you follow under that exception. So a manager under the Employment Standards Code has to hire, fire, demote, suspend, all of those things to be a valid manager. And NIGARD found that out the hard way, that just calling a person a manager without actually being a manager doesn't exempt them from overtime. And so we have clear cases on that. So that's my key overtime tip, is to understand where and when you have to pay it so you don't accrue this large liability.
Shereese Qually. She is our expert on top employment tips from the law firm of Taylor McCaffrey LLP. Shereese, thanks very much for joining us.